Andarki Shubhodayam. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Right. Punjab and Haryana High Court, they came down heavily or they expressed strong judicial censure. What is this nonsense? When an accused in a case of death due to rash or negligent driving came to the court for quashment because they have effected compromise outside the court. So this cannot be allowed. This cannot be tolerated. Justice Sumit Goyal of Punjab and Haryana High Court in the case of Satnam Singh versus the State of Punjab and others. This is criminal revision number 59021 by 2025. On November 20th, just 2 days back, November 20th, 2025, the High Court employed strong judicial censure by warning that practice of compromise-driven quash petitions, so కొన్ని సందర్భాల్లో కాంప్రమైజ్ ఒప్పుకుంటారు. It should not become a practice. So practice of compromise-driven petitions, they threaten the integrity of the judicial process, integrity of the criminal trials, and it dilutes the so-called rights of the victim, particularly in the case of 304A of the Indian Penal Code. I think presently it is 106 of the Bharatiya Nyaya Sanhita. Going to the facts of the case, this relates to crime number 48 by 2022, registered under section 304A and also 279 rash or negligent driving IPC of Ajit Wal PS of Moga district in Punjab. Of course, the evidence is there. What happened is on 8/6/2022 at about 6 p.m. the complainant son, that is it పేరేంటి సోను సింగ్ అతని పేరు ఉన్నాడు కదా, his son Gurjit Singh, complainant son Gurjit Singh, and another person by name Ashpreet Singh. Both of them were going on a motorcycle. And behind them a JCB came, JCB driven by the so-called Sumit Satnam Singh, came in a rash or negligent manner, hit the motorcycle from backside. They fell down, and this JCB dragged the motorcycle to some extent and left it there. The result, complainant son, even though he was admitted in the hospital, actually complainant was also going on another motorcycle. So shifted them to the hospital, but no use. Ultimately, his son died. So they registered the case, arrested the accused, and the trial court gave him, 6 months trial. Anyway, conviction was given. Against the conviction was given on 7/4/2024. Incident in 2022, conviction was on in 2024. Immediately, maybe after 3 or 4 days, the accused person approached the relatives of the victim. We don't know what happened, but they came to a compromise that he has paid 13 lakhs to the family, to the bereaved family. They effected compromise. Later, basing on the compromise deed, his advocate filed a petition under section 482 CRPC, presently 528 of the Bharatiya Nagarika Suraksha Sanhita, to quash the proceedings as the matter was financially settled outside the court. Right, the advocate on behalf of Sonu Singh, Satnam Singh, submits that all the disputes arising from the so-called incident are settled, compromise reached, therefore proceedings may be brought to an end. But state, will it keep quiet? State opposed that offense involved in the death of a young man who is the breadwinner of the family, and it could not be quashed due to compromise. Of course, the provision is also not there in the entire BNSS or CRPC. Now, Honorable Justice Sumit Goyal, he said, the practice of entering into a settlement may be involving the so-called pecuniary consideration, but it creates a very bad impact. Please remember, it creates a very bad impact on the societal psyche. యాక్సిడెంట్ చేయొచ్చు, డబ్బులు ఇచ్చి తప్పుకోవచ్చు. అఫ్ కోర్స్ మన దగ్గర జరిగేది అదే అనుకోండి, వేరే సంగతి. బట్ యూ కాంట్ కమ్ అండ్ సే లైక్ దిస్. Please remember, such an outcome is antithetical, and also against to the rule of law. Because this severity of the law is, it cannot be insulated from the private financial arrangements of both parties. So basing on the very famous landmark judgment, Union of India versus v.sriharan alias Murugan and others 2015, the court said no quashment. ఈ వీడియోలో మీరు గమనించాల్సింది, ఎందుకు ఈ వీడియో చేసింది, సహజంగా చాలామంది మీలో తెలిసే ఉంటుంది, యాక్సిడెంట్లు అయినప్పుడు ఎక్కువే చేస్తుంటాం, మనమే చేస్తుంటాం రాజీలు. ఒక ఆయన తెలియక జడ్జి గారి దగ్గర, మీ ప్రజెంట్ జిల్లా జడ్జి భారతి మేడం దగ్గరే, ఇన్ దిస్ కేస్ యువర్ ఆనర్ వీ ఎఫెక్టెడ్ కాంప్రమైజ్, నేనే వాళ్ళకి 6 లక్షలు ఇప్పించాను, ఇన్సూరెన్స్ ఉంది, ఇన్సూరెన్స్ ఇచ్చేయండి అన్నాడు. Then the judge said immediately, no, you should not say like that. What happened outside the court is not material to us. You produce the evidence, you say what are the facts, that's all. ఎంఈ కేసుల్లో బయట జరిగింది మాకెందుకు. అలాగే ఇక్కడ కూడా బయట జరిగిన పక్కన పెట్టి దానివల్ల క్వాష్మెంట్ జరగదు. సింపుల్గా ఆ విట్నెస్ని హాస్టైల్ చేయించుకుంటే అయిపోదు కదా. అఫ్ కోర్స్ హియర్ ఇట్స్ అపీల్ మ్యాటర్, దానివల్ల వీళ్ళు వెళ్ళింటారు. కాబట్టి యూ హ్యావ్ టు థింక్ ఆఫ్ బోత్ సైడ్స్. And then only you will understand the case properly. I am stopping here. Thank you very much.